Okay, this video is on Chapter 13, written by Steckley and Cummins, and it's on treaties. So the article starts out with the question, what is a treaty? So generally, it's understood that treaties are agreements where Aboriginal people give up their rights to a piece of land in return for the creation of a reserve. And the details about reserve creation, size, location, and all of that stuff is really developed and is really come to in a number of ways. In some cases, it's just arbitrarily assigned to the native community, and or in other cases, it's negotiated through consultation. The reserve location is really important because some very significant mistakes in history have happened where people were placed in a situation where the land was not conducive or not facilitative of a traditional way of life. And that really caused long-term problems for Aboriginal people. These are not well thought out locations for reserves. Yeah, so some locations were assigned and some locations were consulted with. So the treaty signatures, the people who signed the treaties got two kinds of payments. One payment was for the initial signing of the treaty, and secondly, they got an annual grant of $5, $6, whatever dollars to maintain to symbolically maintain the agreement. And chiefs, like today, in all cases, always got more than the average band member. The treaties also talked about Aboriginal liberty to hunt, fish, gather, fowl, I guess that's ducks and things like that, as they've always done. In some cases in unoccupied territory, like in the Douglas Treaties, and in other cases through the local areas that were there. The only stipulation that has kind of developed through the court cases is the situation where hunting rights are in conflict with international agreements around conservation, and the one that is mentioned in the article is the Migration Birds Convention Act, where Aboriginal people could not use Aboriginal rights to hunt those particular birds. So those are some general statements about what treaties are. Then the article gets into a number of specific treaties. The Mi'kmaq is the first one. The Land Surrender Treaties is the second area. The Douglas and Number Treaties is the third area. And the What Can Go Wrong section on the treaties is, the shameful treatment and neglect and ignorance displayed towards the Mississauga people and their rights to continue to be themselves. Finally, urban reserves are discussed, and the Nisga'a Treaty is discussed. So, we will talk about the Mi'kmaq treaties. The Mi'kmaq treaties are the oldest. These are treaties of peace and friendship. They do have elements of freedom for Aboriginal people to go hunt, fish, fowl, etc., etc., etc. And the only obligation that the Maliseet and the Mi'kmaq had was to keep the peace. And I think this is under British treaty or law, it is in the 1700s. So the number of treaties, and I have to read this because I'm not going to memorize it, but in 1713, the Mi'kmaq signed the Treaty of Portsmouth. 1725, they signed the Mascarene Treaty. 1752 was known generally as the Peace and Friendship Treaty. And then there were a number of court cases that kind of moved back and forth in terms of what these treaties actually meant. Rex versus Silly Boy came out with the conclusion that the court said that they're not sure if Aboriginal rights can be protected under the Treaty Act. So goody. But in 1958, the Supreme Court, Simon versus the Queen, recognized the supremacy of the 1752 Friendship and Peace Treaty that said that provincial laws had to be amended or changed or positioned in such a way where Aboriginal rights, the Mi'kmaq rights, the hunt, fish, blah, 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 were protected. One of the issues that came up is, like, what is reasonable in terms of using Aboriginal rights to gather resources. We have a very similar problem in British Columbia, where Coast Salish and other Aboriginal groups on the coast who have the right to Indian food fishery, a moderate livelihood to feed themselves, their families, and their communities. They've argued that, well, wait a minute, in contemporary terms, that Indian food fishery can translate into commercial food fisheries, where through the economic system, capitalism and market and all that stuff, they can indirectly continue to feed themselves, their family, and their children. The same issues came up with the Mi'kmaq treaties, and to this day there does not seem to be any resolution. Okay, so moving on to land surrenders. Canada basically was constructed through a series of land surrenders and public purchases, where land was bought through treaty making, where Aboriginal people gave up their claim, I think, on these lands in return for reserves. So Canada and Ontario took its shape, Toronto took its shape from these land purchases via treaty. In Ontario, there are what is known as the Robinson Treaties, starting in 1850. I have to read this. So these treaties, were from north of Lake Superior and Lake Huron. All of them were motivated by the discovery of minerals and resources, and the government wanted in there for their buddies and friends. So once the government wanted something, you could be sure that the treaty negotiations would start. Otherwise, there's no need to negotiate with Indians. That's the attitude. So in the Robinson Treaties, I'm just reading this, natives received no compensation. Oh, okay. So what happened, and one of the conflicts in how the Robinson Treaties came to be, was that there were minerals in the earth. White people, the government already went in. There were no treaty making. The Mi'kmaq people, the people who were in that Robinson Treaty area, were not receiving any compensation. So what they did is they used their numbers to close the mine down. So the federal government responded by sending in the troops, and then started to negotiate the treaty that led to the Robinson Treaties, and created a little bit of clarification around resource development. On the west coast of Vancouver Island, we have what is known as the Douglas Treaties, signed by Governor Douglas, who overall is seen as kind of a progressive guy, only to be undone by the next governor, Governor Trudge, who was so anti-Indian. Essentially, Governor Douglas's approach was not to pay cash, but to provide goods like blankets and other goods in lieu of cash, to create friendship treaties, and to create very small reserves. When Douglas was out of resources, he stopped making treaties, so he made sure that he had the ability within the colonial budget of Vancouver Island to pay those costs. The reserves were characteristically small, and it made it difficult for the Coast Salish people to actually make good with the land, make use of the land. But at the same time, it was often a place to get out into the ocean and hunt and fish and whatever. The other problem was that a lot of the reserves in British Columbia in 1871 took the form of the Douglas Treaties, were very small in size, and then in 1912 or whatever, it's not covered in the book, but in 1912, Trutch took even what little land there was and made them smaller, and that was all resolved recently, and the coast sailors were reimbursed for that useless cutting back of reserve space. According to the Douglas Treaties, the Aboriginal people, the coast sailors, could continue to hunt, fish, gather, all that stuff in unoccupied territory, which was great in 1870, but you can imagine West Coast, Vancouver Island, beautiful. It is no longer possible. So there is a court case, I'm just referring to it, I don't know anything about it, but it's in 1965, Regina versus White and Ball. And I was negligent to research that, but essentially I think it affirmed the fisheries aspect of Aboriginal rights. I'm not sure on that one. Okay, number treaties is basically from Treaty number 8 in Peace River, British Columbia, up into the Yukon, Treaty 11, I think, moving through the prairies, and then finally finishing off in northwestern Ontario. These were numbered treaties. They were clearly motivated by Canadian expansion west and by the federal purchase of Rupert's Land, which was given to the Hudson's Bay Company. Moving back, Rupert's Land was given a charter so that this British company under King George III or IV or whatever could claim ownership to all the lands drained by the watershed leading into the James Bay or the Hudson's Bay area. And that included like pretty well all of Western Canada. And I think the western and the eastern subarctic regions were, I think, all within the watershed of the Hudson's Bay and James Bay. So those two developments in history created the need, created the process of developing the number of treaties. There are 11 treaties signed in the period from 1871 to 1921. And the 1921 treaty, Treaty 11, goes right up into the Yukon, and is based on the feds wanting access to the oil identified in the Norman Wells. So anytime there was a need to harvest resources of any kind, whatever Canada wanted, that was a motivation to purchase the land and to make treaties with Native people. So that's an overview of the history. Then the authors really got into the Mississauga experience, the Mississauga treaties, because this is a shameful history where a lot of promises were made. But when the Aboriginal community in that area, in the Mississauga area, Toronto, actually practiced their rights according to the treaty, they were sabotaged by white settlers. Their fishing things were destroyed, their nets were destroyed, their reserve community was destroyed, they were personally attacked, and all this without the protection of the government and the police, the Northwest Police or whatever they're called. Those were implied at least in the promises of the Mississauga treaties, but the government failed to protect Aboriginal people, and they failed to protect Aboriginal rights. So this is a what can go wrong scenario. If it can go wrong, it will go wrong with the Mississauga. So again, public purchases formed what's now Northern Ontario and what is in fact Toronto. Toronto purchases and so forth. All of this is Mississauga land. I apologize. The public purchases were done in Northern Ontario, but what we're talking about is the Toronto, Mississauga area, which we know by the cities today. Toronto was developed through treaties and the Toronto Purchase and so forth from the Mississauga Nation. So that's how the Toronto area was developed. 1805 marked the beginning of the treaty process with the Toronto Purchase. And then I already said that this is a sad story in Canadian Aboriginal relationships. In 1812, that was a revolution year. The British were the majority of the population in the Toronto area, and with the Mississauga, being only 10% of the community. So that meant a lot of political pressure to use treaty money to educate and Christianize Mississauga people so that they could become Canadians. I guess it was progressive in their time and place, but it was also the forerunner of the residential school thinking. Take away the language, Christianize them, and so forth. So this was the experience that the Mississauga felt at the early 1800s. Mississauga eventually lost lands, and their Aboriginal rights were very subjective. They weren't quite sure what the rights were anymore, and eventually Mississauga lost. And again, it's a sad part of history, which is slowly being addressed through courts and claims and research. So that's a good thing. So urban reserves. Urban reserves are relatively new. They are an interesting concept. In the 1990s, it started in Saskatchewan, which has a high Aboriginal population in the first place. And the first reserve was the Muskeg Lake Cree Nation, who worked with the city to get 33 acres dedicated or allocated to the status of Aboriginal reserve. So federal and provincial legislation had to come into line, had to create the environment where this was legally possible to do. And that legislation does exist in Saskatchewan and in the federal government today. What it does, it recognizes that the 50% of Aboriginal people now live off reserve. Women fleeing violence on reserve, people looking for economic opportunities and/or jobs and/or ways to establish and maintain a business. And the city provided more backup, more ability for Native people to do this kind of thing. So that was the rationale. I think it was basically an economic development argument that created the environment to make Aboriginal reserves, urban reserves, an interesting concept, and a very doable concept, and a concept that benefits the economy generally. In Saskatoon, as an example, the Aboriginal business there have created 300 jobs at the time of the writing of this article. So it's a lot of good stuff. So yes, lands located, provided a central place for Aboriginal business. Provincial legislation enabled the province. Federal and provincial funding was identified, and the on-reserve communities bought in. And in fact, the on-reserve communities pay a proportion or an amount to the city for the provision of city services. So everybody's a winner here. The reason that urban reserves were successfully developed in Ontario is Saskatchewan. Number one is that a lot of the land delivery under treaty was still outstanding. So this was a way of making up lost ground for the federal and provincial government. Secondly, the high percentage, about 50% of our people live off reserve and in urban settings. And the third is the economic development opportunity, business, and so forth. the feds and the First Nations, for various reasons, really wanted and put their cards in the area of economic development. And that was a very good thing because it increased self-sufficiency, and Native people were less and less dependent upon the government coffers, which is controversial in itself because government still has a fiduciary responsibility towards Aboriginal people, blah, blah, blah. Okay, so that's about it. At the end of the day, 300 jobs for Native people are created in Saskatoon, and I think that alone is worth considering urban reserves as something important. And the final point of this long video is a Nisga'a Treaty. When I first heard about it, I was kind of disturbed. I thought it was a bit of a sellout. But I think these things kind of grow on you and whatever. So, in the Nisga'a Agreement, and in the article, they have a whole chronology, 2 pages of it, which I'm not even going to try to remember, but it's a good reference point. This has been going on a long time. I think it started with the Native Brotherhood, which is a fisherman union, who in the 1920s started this process. But anyways, so the federal government returned 1,930 square miles of the Nass Valley to the Nisga'a. They spent about $487.1 million in benefits and housing. They enabled through the Nisga'a Act the ability for self-governance, where the Nisga'a could enact laws around land use, employment, and cultural preservation. The Nisga'a, as a group, are private owners of forest and mining companies, and they operate like any other British Columbian in terms of being an owner. They pay taxes. They gave up their tax exemption in terms of those ownership issues. And they gave up they gave up not the sovereignty, but the claim of title. And I don't quite understand the legal differentiation. That's something that I need to learn. The Nisga'a gave up 80% of their land and their tax exempt status. So I don't know. Like the Tawasin agreement, it kind of, you have to give up some stuff in order to get other stuff. But I think in both cases, these agreements gave more flexibility for Aboriginal people to develop opportunities for the people. They weren't as stuck in the little framework or little box dictated to by the Indian Act. And the majority of Nisga'a wanted to do this, so that alone has to be respected. It's their choice, their decision as a people. So, in my view, I haven't made up my mind about the Nisga'a or the Tawasin or the Seashell agreements in British Columbia. All the same model of giving up setting aside certain Aboriginal rights in exchange for flexibility to participate in the economy of British Columbia and bring more money home. So that's the chapter on treaties, and I will leave it at that.